Hello and Merry Christmas. Today is December 26, 2019, and this is your Virginia 2A update. Our situation report today is going to deal with three things. The Virginia Capitol may be going gun-free, the Attorney General says that sanctuary cities are unlawful, and Guardsmen speak out about sanctuary cities. The vote that flipped the balance of power from Republican control to Democrats in November 5, 2019, is now going to have its first weigh-in of power flip on January 8th. The incoming House Speaker is considering and discussing going gun-free for the Capitol area. Incoming House of Delegates Speaker Eileen Filler-Corn confirmed Thursday that Democrats have considered and have been discussing the possibility of banning guns on Capitol Square. This position is likely in response to groups which plan to lobby Virginia lawmakers for Second Amendment rights. And of course, this being against the core value of the Bloomberg-funded Democrats, changing the law would change the optics on the event, greatly reducing the visibility of what gun owners are fighting for in Virginia and disallowing them the ability to humanize gun owners in Virginia from others who may not understand the struggle. Lobby Day, which VCDL has planned for January 20th, and the other days that are going on from other organizations starting January 8th, all have to do with humanizing gun owners and taking away the stigma of gun ownership. Remember, gun owners, specifically concealed weapon permit holders, are some of the most law-abiding citizens in Virginia and across the nation. This is something that the media often forgets when portraying gun violence. The proposed gun ban on Capitol Hill by incoming Democratic House Speaker directly affects the ability of Virginians to humanize themselves in this way. Yet, it goes further than that. The proposed Virginia legislation criminalizes activities, behaviors, and firearms that are currently legal and make up the vast majority of sporting, hunting, and self-defense rifles and firearms. Yet there are still Virginians that don't understand why this is so important. The laws haven't even been debated in our General Assembly yet. I asked Philip Van Cleve to comment on this point. Here's what he had to say.
Well, the threats are there. The governor has said that he's going to be putting in these bills. He expects them to pass, and these bills are aimed at people like you and me. They're aimed at law-abiding citizens. None of this stuff is aimed at criminals. So basically, they've declared war on Virginia's law-abiding gun owners.
Yet Virginians combat lawmakers with the Second Amendment sanctuary city movement. This movement gathers citizens and the Board of Supervisors or the city management and asks them to declare a sanctuary status for the Second Amendment. So far, 87 counties, 11 cities, and 16 towns in Virginia have sworn to uphold the Second Amendment. The verbiage may change from city to county, with some language being stronger than others, but the message to Richmond remains the same. Do not mess with the Second Amendment. Virginia Attorney General Mark Herring has been listening and responds very sharply. He says that resolutions for sanctuary city counties have no force of law and that cities and counties cannot choose which laws to abide by when it comes to state law. However, many Virginians don't understand how the Attorney General could make such a statement. Aren't such laws repugnant to the Constitution and therefore null and void? Va2A News spoke with Attorney Tim Anderson of the Virginia Law Office outside of Chesapeake. Here's what he has to say.
So one of the first cases you learn about in law school is a case called Marbury versus Madison. And in that case, there's some law that comes from the Supreme Court that says that we don't have to follow repugnant laws. All right. The problem with that argument is this, is that the Fourth Circuit Court of Appeals, which is the federal circuit that covers our district, has ruled that the Maryland assault weapons ban is constitutionally valid. It ruled that it's not an ex post facto violation. It rules it's not a taking violation. It rules it's not illegal to make people felons overnight. So the problem with those arguments is that the highest court, and the court that controls Virginia, says that these are valid laws. These are constitutional laws, and Virginia is modeling the Maryland example in a lot of ways. And so,
what Tim is explaining is a tough pill to swallow. The courts have been working hard in the background, and there are many years of case law and precedents which have already been set, which are the current rules for which Virginia is modeling their gun bans. And as such, it most likely will pass. That means that cities and counties and towns, and lawyers like Tim and citizens like you and I, must think of new ways to combat this unjust usurpation of our Second Amendment rights. Tazewell County in Virginia did just that when they ordered to fund a militia. This militia order is important because it states specifically that the people must have certain arms. As the smallest unit of our government starts at the county level, Tazewell ordering the militia to maintain certain arms and to fund a militia may very well grant protections from the incoming laws on Capitol Hill. This, however, remains to be seen, as it has not yet been challenged in court. This is the type of thing that Tim Anderson is speaking about when he says finding new ways to address these questions. On the heels of Tazewell's militia vote and formation was Virginia's 4th District Representative to the House of Representatives, Donald McEachin, who stated that the governor could and should use National Guard troops to enforce law in Second Amendment sanctuary counties or any place that the governor deems fit. It even implies the use of National Guard troops as a policing force, whereby going door to door to take rifles could be an option. These kinds of statements are completely opposed to Virginians' way of life and the way of life of Americans across the nation, and as such, rightly drew outrage. An anonymous National Guardsman wrote to Donald McEachin in an effort to inform the representative just how far overreaching his statements were. The bulk of the letter, which is published in its entirety on Law Enforcement Today, dealt with questioning why a U.S. representative would even consider using troops against citizens of this great nation. The letter was also clear in the fact that Guardsmen do not agree with this, and many would lay down their arms rather than accept an unconstitutional order to turn on the citizens of the state or the nation. The Guardsman spends a length of time explaining to McEachin the purpose of the Posse Comitatus Act and how it applies to the situation of using National Guard troops against its own citizens. The Posse Comitatus Act forbids the use of federal troops as a standing army against the citizenry of the United States, with a special exception of the National Guard. This exception is one reason that Don McEachin thought he could use the National Guard in a policing action against the citizens of Virginia. However, the problem here is a simple misunderstanding that McEachin has of the different titles of National Guard status, that of federal duty and that of state duty. The governor of Virginia, or any other governor, has a right to call up their organized militia, the National Guard, in use in state emergencies. However, the type of emergency and the title of role that the National Guard will be used is important here. Title 10 is federal law. Title 10 would mean that if the National Guard was being used in a policing operation against the citizens, that they would be acting as a standing army, and thereby disallowed by the Posse Comitatus Act. However, Title 32, which is a state duty, would allow the National Guard to assist during times of distress or emergency. We generally see this type of use of the National Guard when a national disaster happens. Here, the National Guard is offering civilian aid and not policing. It is this fundamental misunderstanding in the use of the National Guard and of the general law surrounding the Second Amendment in general that is dangerous to our citizenry. The next couple years will be fraught with tough political battle, both on Capitol Hill and at our sanctuary city meetings. You can help. Do not vote Democrat. Democratic viewpoints are viewpoints that are opposed to the Second Amendment and the well-being of the United States Constitution and Constitution of Virginia. The second thing you can do is get involved. Be involved with your local politics, city council, and board of supervisors. Be aware of what's happening around you politically, and make it known on forum posts, Facebook, Reddit, wherever you can get your voice heard. Organize and take action. Together, we can bring back the Second Amendment to Virginia, and if we're lucky, make sure that it never went away in the first place. I'm Robert Ham for Virginia Second Amendment News, reporting for your rights. Thank you for watching.